Good morning, friends. I hope you all are fine. Today, I had a very interesting arguments in a matter which deals with provisions section 145 and 146 of Code of Criminal Procedure. Here in this video, I will share what all disputes are covered by section 145 and 146, who is the authority to decide such disputes, and what things, what ingredients the authority has to see before passing any order regarding section 145 and 146 CRPC. So in starting with what is section 145 CRPC. Section 145 CRPC covers the disputes related to immovable property, land, water, boundaries, wherein two persons who have a dispute related to possession and there is an emergent situation that may cause a breach of peace. Under this provision, upon any information which is on the basis of a report filed by a police officer or any other information from any other source, the executing magistrate, who is empowered under this provision, will have to stand by a procedure which has been enshrined under section 145, that if such information of such dispute comes before the executing magistrate, then what is the procedure which he has to follow to pass any order. So, before passing an order under section 145, the executing magistrate has to see whether there is an emergency situation which may likely to cause a breach of peace by issuing notices to the other parties and giving them an opportunity to file the written statements on the basis of police report, and all these aspects the executing magistrate has to see. If such a dispute happens and if executing magistrate is satisfied, then under section 146 CRPC, the executing magistrate has a power to attach that disputed property and to appoint a receiver for taking care of that property. Nowadays, these provisions are basically sometimes misused also by the people using different sources, milibhagat kalli, police se, all these things. But Honorable Apex Court and different high courts has observed in their judgments that such provisions should be invoked only in emergent situations, and even if executing magistrate is satisfied, then also he has to submit his reasons, his findings for passing that order. Recently, we have argued a matter before the Rajasthan High Court, wherein an order was passed under section 146, which was not preceded by a section 145 order. In that matter, we argued that there was no such emergent situation, first of all. Secondly, even the performa of writing an order has to be that section 146 relief order has to be preceded by preliminary order, that is section 145(1) order. Before issuing notices to the other persons, parties involved, before seeing that actually there is such emergent situation or not, such orders of attaching the disputed property and appointing a receiver shall not be passed. Arguing on those facts, according to the facts and circumstances of that case, and as per the law laid down by the Honorable Apex Court regarding these provisions, the Honorable High Court stayed the effect and operation of the impugned order which was passed by the subdivisional magistrate in this matter, which I argued, who happens to be an executive magistrate. If there is any other doubt, clarifications, or if you want that I should make a more elaborate video on this, then please share your comments and like this video if it is helpful for you. Thank you.